Hello, everybody.
The next matters are two people versus Alfred Perry Hazzard. The first file number is 22S29099FH. The second is 22S29319FH. Mr. Hazzard appears by video from the Montcalm County Jail. His attorney, Ms. Reed, is present in court. Today is the time and date set for a probation violation status conference. Your Honor, I've had the opportunity to speak with Ms. Reed. My understanding is there's pending charges coming in Mecosta County. We'd asked this court this matter to be adjourned until the 12th of September.
All right, Ms. Reed, is that accurate that your client is in agreement to adjourn until after that date?
That's correct.
Okay, so is that the date or just after?
We'll just do it on the 12th.
That's one of my docket days.
Correct.
Yes.
Okay, so we'll adjourn this out to the 12th of September at 8 a.m.
Thank you, Your Honor. Additionally, my client has asked if this court would address bond. His bond is currently denied, so I'd ask the court to review that and consider granting him a reasonable bond.
Okay, well, Mr. Valet, do you have a position on addressing bond today? And if you do, what would be your position?
I'm happy to address bond today, Judge. I think it's a terrible idea to change the bond. Mr. Hadrich has new pending charges in the case. Well, they have not been filed. They've received the reports. They've not been filed yet. But we expect that there will be charges coming from Mecosta County that would both be felonies, including, I believe, methamphetamine and cocaine charges. But again, they haven't done them. But I would also point out here that the recommendations here, his guidelines in one file were 10 to 23, they're 5 to 23 in the other. If he has new pending charges, I'm expecting those will also be in that range. The recommendations in this case are for prison. As the court may notice, he has not only had an original five count probation violation, but now it's had 4 new counts for a total of 9. Mr. Hadrich hasn't got things going his way. I think he is a risk to himself. I think he's a risk to the public at large, and I'd say that there's a substantial reason if the court was to lower his bond that he may not want to show up, because I don't know how he will be going to prison.
Ms. Reed, then your position.
I have no further comment, Your Honor. Simply asking the court to grant him a reasonable bond.
All right, so the purpose of bond is twofold: is to ensure the protection of the public and to ensure the appearance of the defendant. Now, the defendant does have prison guideline range on the charges here that he's serving a period of supervision for. That certainly can create a risk of somebody not appearing. I haven't heard anything that would suggest that he would appear. In other words, allocution on his behalf, that he has a plan in place, a place to go, things of that nature. I recognize there are only allegations, but the court also has in front of it the allegations that he has failed to abide by court orders already. That addresses both prongs of the court rule dealing with bond: appearance of the defendant and protection of the public. So there's no doubt that there are concerns about his appearance. There's no doubt that with allegations that he is going to be charged with new crimes, that the protection of the public also comes into play. I'm comfortable with the idea that there be no bond in the interim until we can address these issues. I also think it's appropriate analyzing it through the court rules. So respectfully, court will decline to amend this bond at this point.
Thank you.
All right, what else do we have today?
We have Jesse Stevens at the jail, please.
All right, Ms.
This
Krause.
is people versus Jesse Stevens. I don't have the file number.
It is 24K30978.
So it's my understanding he's going to plead no contest to the probation violation. Understand this is a Judge Krieger case. We do have motion day next Tuesday, so we can just set it for sentencing next Tuesday.
All right, and then so next Tuesday would put us, you mean Thursday, right?
No, we've changed to Tuesday next week.
August 20th, Judge,
Oh.
is her docket day.
August 20th.
Yeah.
Okay. All right, and Mr. Stevens, is that your understanding that's going to happen today? You're going to enter our plea and then you'll see Judge Krieger in a week?
And in addition, Ms. Kraus, you are not going to bring any further charges.
Correct.
All right, is that your understanding, Mr. Stevens?
Yes, sir.
Okay, then I'm gonna have to have you raise your right hand. If you could raise your right hand. Do you solemnly swear from a testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
All right, you can put your hand down. So you're being supervised for the underlying charge of possession of a narcotic less than 25 grams, and it has a maximum penalty of 4 years. Do you understand that, sir?
yes, sir.
Do you understand that if you go forward with a plea here, that you won't have a hearing of any kind on the probation violation, but you would be entitled to have a hearing? So are you waiving your right to have a hearing?
Yes,
All right, when you waive your right to have a hearing, that means you're waiving all the rights that would come with the hearing. I have to describe those for you. It means that you're waiving the right to be presumed innocent of the probation violation. It means you're waiving the right to confront any witnesses that might be called against you or to call your own witnesses. It means you're waiving the right to testify at a hearing of that nature or not say anything, and then the trier of fact could not use that against you. It also means that you're waiving the right to have the assistance of an attorney at a hearing. You have Ms. Shear, she could be with you through the hearing if need be. Mr. Stevens, are you waiving all of those rights?
I do believe so, yes.
Okay. Has anybody promised you or threatened you or done anything else to you to get you to enter a plea here this morning?
No,
Has anyone else said anything to you about what your sentence might be as a result of entering this plea?
no,
All right. Recognizing that I'm only taking a plea, you will actually see Judge Krieger for sentencing. Does that change anything for you about wanting to go forward with this plea today?
no, sir.
Okay. Let's talk about the alleged violation then. It says that you violated the terms of your supervision on or about August 14th of this year. And when you engage in assault of abusive, threatening, or intimidating behavior, specifically that you kicked in the door of your mother's office and was displaying threatening behavior towards her. How do you plead to that allegation?
No contest.
Your Honor, the basis for the no contest plea is both criminal and or civil liability.
Okay, any objection to the no contest?
No.
All right, so then what do we have for a factual case?
Ms. Kraus and I talked about that. I believe under the court rule that because the nature of the violation in the summons itself has facts that the court could accept it on regarding the door being kicked in. And we agreed to take it on that.
Correct.
Well, what about the second half of the sentence then? I mean, kicking the door, and I don't know by itself is assault of abusive or threat. I mean, what if it's his door? Like, I think we need to get to, is he agreeing for purposes of the plea? The second half of the sentence also is factual.
Yeah, for the purposes of the plea, yes, Your Honor.
Okay, so the court will take a factual basis based on the request and summons that indicates that he kicked in the door of his mother's office and displayed threatening behavior towards his mother. In addition to that, kicking in the door combined together certainly would be something contemplated by the terms of his supervision and not engage in assault of abusive, threatening, or intimidating behavior. Anything else on the facts from either side?
Oh, yeah.
No, thank you.
Okay, back to you, Mr. Stevens. Again, other than what we've talked about here today, nobody's promised you or threatened you or done anything else to you to have you enter this plea, have they?
No,
Do you want the court to accept your plea to violating your probation?
yes, I do believe so.
Okay, I will accept your plea, Mr. Stevens. You offered that plea freely, accurately, and voluntarily. So I'm gonna put this on for sentencing with Judge Krieger on August 20th. That'll be scheduled at 8 a.m. And on that date, you'll come back and Ms. Shear will be here on your behalf, and Judge Krieger will hear from the people in probation and your attorney and you if you wish to provide a statement, and then she'll impose what she thinks is a appropriate sentence. Anything else?
No, thank
No,
you.
thank
So we should probably address bond then, since bond position. Ms. Kraus,
you. Yeah.
Ms. Shear.
Your Honor, I'm asking the court to consider a reasonable bond in this matter. Mr. Stevens is unemployed, is not receiving disability at this point. receiving no income, so he wouldn't be able to make obviously a substantial bond. So we're
So he's living off of his mom too.
asking the court to consider that here.
All right, I'm gonna adopt the recommendation. I'm gonna impose a bond of 50,000 cash or surety. Now, the purpose of bond is twofold: to ensure the protection of the public and to ensure the appearance of Mr. Stevens. I haven't heard anything that would suggest he wouldn't appear, but I have taken a plea now. So there's a post plea that does say that he has violated court's orders already, that he is engaged in abusive assault, threatening behavior. So I think a bond is appropriate. It is an assaultive type violation that has occurred here, and drugs is the underlying offense, and combined together, that's not helpful. So I'll set bond at 50,000 cash or surety, and certainly as part of his sentencing, when he sees Judge Krieger, all those issues probably can be addressed. Okay, that'll conclude the matter. You'll see Judge Krieger next week, Mr. Stevens.
Could we have Mr. Farr?
Yeah.
Farr. Wow. Our next matter for the court is People versus Matthew Robert Farr. It's file 24S 31479FH. Mr. Farr appears by video from the Montgomery County Jail. His attorney, Ms. Shear, is present in court. Today is the time and date set for sentencing.
All right, Ms. Shear, you had an adequate opportunity to review the pre-sentence report, to sense any information with your file.
I have, Your Honor.
Additions, corrections, or deletions?
The only correction, Your Honor, would be on page 9 under the marriage section. There was just a misspelling of his son's name. It's the fifth box down, Colton Edwin. It says Spencer. It's actually Spence with no R on the end of it.
All right, you can make that correction. And
That-
then,
That is the only factual correction, Judge.
okay. And then with that, do we have accurate information on which to base on?
Yes, I'm sorry.
Okay, Mr. Lilly, anything on behalf of the people?
Here, I ask you to follow the recommendation. It is an agreement with our plea agreement here, and it's appropriate enough.
Okay, Ms. Shear, how about you?
Your Honor, the recommendation is in line with the recommendation. We would ask the court clearly not to exceed that and to follow our agreement in this matter. The only thing that I would ask the court to consider here, Mr. Farr was arrested on May 21st in Newaygo County. Obviously, reading through the report, he was charged in Newaygo County for the same thing, all part of the, what I would call same transaction and occurrence. He is pending sentencing there, but again, he was arrested on May 21st in Newaygo County and then was brought here. He had a hold on him in Montcalm County. He wasn't arraigned here until May 31st, and that is when Ms. Vanderveen had recommended the credit start, was when he was arraigned here. I would ask the court to consider giving him the 10 days that he was in Newaygo. Again, it was all part of the same transaction, so to speak. And Montcalm did have a hold on him. As a matter of fact, the warrant was issued the warrant was issued in this county, issued and filed on May 21st, the same day he was arrested in Newaygo. So I would ask the court to consider granting that additional 10 days to Mr. Farr.
Mr. Lilly, what's your position on that?
Well, I think you can consider that, Judge. I don't consent to it. I think he was arraigned in a reasonable amount of time after the warrant was issued here, 10 days. So if you give him 10 days, fine, but I don't think he's entitled to it.
Mr. Farr, anything that you'd like to say before the court closes sentence?
No, Your Honor.
All right, Mr. Farr, you stand before the court today for prior felonies, a prior misdemeanor, and a really serious incident that occurred here. So I think you got a very favorable deal out of all of this, considering your history and what occurred here. When I read through the narrative here, it reminded me of Friday nights when I was a kid watching the Dukes of Hazzard, but we're not in Hazzard County, driving through people's yards, keeping going, throwing guns out of the car. I guess they were using bows, right? Because they were felons already. Anyway, but that's exactly what was going on here. Chase, it involves 3 counties, unlike the Dukes of Hazzard. You know, once you get over the county line, you're not safe, right? But it was very serious. This is how people get hurt, how they end up dead when people like you are driving in this manner, particularly with felons that have guns. I mean, I really believe that we ought to be thinking about the top of the guidelines. I don't know what you pled to in Macassa County. I'll follow the agreement. I understand there's lots of different reasons to go into agreements, but it's a long way to the court saying that I think you're a danger to the community. Your history would suggest that, this would suggest that. And I hope you're getting more time in Macassa County or Newaygo, wherever those charges were. I'm required and I will impose a $130 crime victim assessment, $550 in court cost, a fine of $500, attorney fees of $400, and a state cost of $68. Ms. Shear has requested that 10 days credit. I concur with the people here. The court's not required to give that. I think I have some discretion. I'm not going to do that for all the reasons I just previously stated on the record. I would prefer to be giving you 28 months in prison as a result of this crime rather than the 18. I am going to sentence you to 18 months with the Michigan Department of Corrections. That will be a minimum sentence to the statutory max of 3 years with credit for 76 days you have previously served. Mr. Farr, you do have a right to seek appellate review of the sentence. If you'd like to do that, you have 21 days from today's date to make that request. If you want a court-appointed attorney to assist you, you have a broader window of 42 days, so 21 and 42. Ms. Shear, anything else?
No, thank you.
All right, Mr. Farr, fill out your appellate paperwork there, and then you're all set.
Be safe, be well,